Let's get a little bit more detail talking about public comment. I've kind of touched on this before. We've gone over it a little bit. We've probably covered a lot of the rules. But again, I want to emphasize there's nothing in the right to know law that says you have to let people speak at a public meeting. But there are occasions where you have to have a public hearing where the public has a right to speak. But a pure meeting under the right to know law, remember those two columns, we had public meetings and then public hearings. If it's just a simple public meeting under the right to know, the public does not have the right to public comment. But you may want to have a public comment period. So you have to have rules of the road. And that's where the ability to regulate speech intersects with your duties under the First Amendment. And the way in which governmental agencies deal with the ability to regulate speech reasonably under the First Amendment is to only regulate time, place, and manner. Anytime government tries to regulate the content of speech, you're going to get in trouble. So that's why the Supreme Court, in its rules that govern the First Amendment, tell government, don't regulate the content of speech, but you can regulate the time, manner, and content, or time, place, and manner of the presentation of speech. So time, you can tell people at a public comment period, they have 2 minutes, they have 3 minutes. That's the time they have. The place is at the public meeting when they're allowed to come up and they can sign up for presentation at public comment period. And the manner, you can to some degree regulate the manner of speech. So speech which is designed to suggest that the speaker wants to engage in fisticuffs with a member of a public body, those are fighting words. And fighting words are not considered to be protected speech. Obscene speech would also not be considered protected speech. However, realistically, use of a four-letter word in the course of a public comment would not be per se obscene speech, so you could not cut someone off when they're using obscene speech of that type. In fact, there's a famous case from California where a young man who was very opposed to the draft walked into a courtroom. This is a case entitled Cohen versus California. He walked into a courtroom in 1968 with a shirt on that had the words F-U-C-K, the draft, in big bold letters on his t-shirt. He walked into a courtroom, sat in the back of the courtroom without uttering a word, sat down and proceeded to just be present during a trial, and a court bailiff came over to him and said, take off the shirt, and he said no. And ultimately he was arrested for disturbing the peace. And the issue was whether or not the wearing of that shirt was in fact disturbing the peace that would allow the bailiff to arrest him and remove him from the courtroom. And the answer by the U.S. Supreme Court Justice Black was no, that is protected speech. We may not like the manner in which he's expressing his opinion, but he's clearly expressing an opinion on a matter of public import. And as a consequence, government cannot regulate the content of speech. So realistically, you're going to have people at public comment use bad words, and that's not going to be enough to cut off their speech. Yes?
But where you say First Amendment, many restrictions are not acceptable, there are restrictions that are acceptable then. If somebody wants to speak to something that's not on the agenda,
yes,
that is unacceptable.
Yes, however, under the First Amendment, you probably have to have a safety valve. So your rules probably have to say, presumptively, public comment if for things on the agenda. But then you also probably have to put an asterisk next to that and have it say, if you want to speak of something not on the agenda, you have to ask our permission, and we will seriously consider your request. And you probably have to consider their request. So if they do want to talk about the weather in Mozambique, and it's not related to anything on your agenda, you might need to give them that flexibility. I'm just being realistic here, because if you just shut out any alternative communication at your public meetings and only things on the agenda, you might run into a problem under the First Amendment. One other thing I would say, however, is repetitive speech is disruptive. So if the same person came to public comment and said the same thing time and time again, you probably could say, sir, this is the third time you've spoken at our public comment period, and you're speaking on the exact same thing, saying the exact argument that you've said the last 3 times, the last 2 times. This is disruptive speech because it's repetitive and it's impeding the ability of government to get the job done. We've heard you once, we're not required to hear the same thing time and time again. That person could be cut off.
What if you heard the same argument against a specific item by different people?
Probably you're going to have to let all those different people make that same presentation. At some point, however, if you could be able to suggest that the same people are saying the same things and they're all part of the same group, you might be able to say, wait a minute, we've heard that before, you're now becoming repetitive speech, disruptive speech. You might be able to cut that off. Realistically, there are strategies a chair can use. Now, I don't know if you've ever been up to the legislature, but if you have a long line of people who all want to speak, you know, what they do at the legislature, they have these cards where you check in and the card says, I want to speak, or I support the bill, or I oppose the bill. And you can even put that on the card. And then you can check you don't want to speak because you've expressed your opinion on the card. So you've allowed the person to express their point of view, and then you give them the opportunity to speak, but they don't have to. A chair could say, okay, Mr. So-and-so, I see you're wearing this shirt that says I'm opposed to Northern Pass, and the 5 people behind you all are wearing the same shirt. Is it possible that you could say the same thing for everyone who's about to speak behind you, and we'll be able to then move forward with everyone in the room, because we have 25 people, and the first 5 people appear to be all of the same group, and they all perhaps would have the same presentation, and the chair might be able to use moral suasion to convince one person to speak for 5. So there might be some way to minimize, you know, a prolonged presentation on the same point of view 5 times in a row. Something to think about in terms of how the chair manages the meeting. Some of the things that you cannot have in a public comment rules of procedure is that only positive comments are permitted. You can't do that. You certainly cannot do, we will not allow criticism of public employees. There have been towns that had rules that say public employees could not be criticized. That would not be permissible. You could not have a rule. There was one particular town that had a rule that said there would not be inappropriate criticism of members of the public body. That would not be a permissible form of regulatory conduct with regards to public meetings and the public hearing process. So long as you limit your time, place, and manner, 3 minutes, stay on topic, be related to something on the agenda, you're just going to let them fly for the 3 minutes, and then you'll move on to the rest of the agenda later on. Yes?
So how do you consider somebody that wants to be disruptive and personally attacking one of the members of the board, and distinguish the difference between their rights under the First Amendment and what you just said a few minutes ago?
Personal attacks, if I'm speaking to a public body and I am saying that council member X is corrupt, that's not going to be a basis to tell the person has to stop speaking. So what I'd like to do is show you a video, and then I want to talk to you about the video, but this is a video of an actual public hearing at a town in the town of Alton. So we just want to bring up, you have to bring up the
Okay, open public input 1, and our rules of public participation is on the back page of the agenda at the table. You enter.
Is it open?
Yes.
I'm going to start my clock here so I don't get shortchanged in my 5 minutes. My name is Jeffrey Clay, and I'm from Alton. And every time I show up here, it is with my most fervent hope that I'm going to find that you folks have resigned. But you still continue to show an unwillingness to step up to the plate, take responsibility for your poor actions as selectmen, and resign. I'm asking you to do that now. It just takes 2 words. Stand up, admit I take responsibility for all my poor decisions, for my poor actions, for the continued violation of the citizens' rights here in Alton.
Point of order. Is this a character assassination?
And resign. All you have to do is stand up and say, I resign. That would be a good thing for you to do, to say, I resign. You just stand up and say, I resign.
We have a point of order at this time.
It's my understanding.
Have a second on the point of order?
It's my understanding that this board does not pertain to Robert's rules of order.
Okay. And you
do not
you feel that he's violating the...
Do you or do you not go with Robert's rules of order?
Libelous...
We won't answer the question,
statements,
right?
Yes.
Is the board feel that the...
You really need to stand up and resign.
Is a libelous...
the public needs to hear you do that.
Discussion?
I got to stop my time here.
All in favor of closing down public input at this time because of the defamatory statements made by Mr. Clay? Say aye. 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 Opposed? Thank you. Public input's closed.
Integrity is the quality of being honest and having strong moral principles, moral uprightness.
You are
it
done,
is
Mr.
generally
Clay.
a personal choice to uphold oneself
Clay,
to consistently moral and ethical standards. Integrity also demands knowledge and compliance with both the letter and the spirit of the written and unwritten rules. To this end, this board is morally corrupt. It is bankrupt.
He can sit in the audience.
It is without integrity. We citizens pay the price. You want to take your hands off me, please? Take your hands off me, please.
You've been asked to leave.
Take your hands off me, please.
You've been asked to leave.
Take your hands off me,
please. Are you going to
please.
stand up and leave?
We citizens, we the citizens pay the price in legal fees for your representation. 2 little words, resign. Am I under arrest?
Come on. You're going to be if you don't listen to me.
Stand up and resign now. Alton deserves better. Audacity is defined as boldness and daring, especially with confident, arrogant disregard for laws and rules and policies.
Clay, you've been warned the 3rd time now.
Continued violations cannot be tolerated by the public.
Public input has been
Stand up, take responsibility for your willful violations of the rights of the community. Resign. Do it now. 2 little words. Stand up and resign. How can you possibly hold...
Okay, now you are under arrest. Come on. Come on. Come on.
Do we have any other public...
He has some...
Oh.
He was trying to get backup.
He's going
Yeah, he was.
But
Okay,
he was trying
yep.
to get backup.
Any other public input? Yep. Could you just move that over Bob for us? That'd be fine. Thank you.
I would just like the record to show that one citizen is very happy with the select people, and you don't have to stand up and resign on my account. I like what you're doing. I've just been running down the agenda, and I see new business.
Okay, so what I would tell you about this particular, if we could just bring up the PowerPoint again, and then just go to the current slide. Yeah, there we go. So this was Alton versus Clay versus Town of Alton. And now, why did the public comment period get stopped? Well, in fact, Alton had a set of public meeting participation rules that said defamatory and libelous statements are impermissible at a public comment period. And it turns out that's in direct violation of the regulation of content of speech. One of the things that is reality if you're a public servant, you're going to have libelous statements of this type by people like Jeffrey Clay made at you at a public meeting. And you're not going to be able to cut them off as he was. Now, he was arrested, and he eventually brought suit in federal court, and in fact, Alton lost because his rights for free speech were tarnished, were stepped upon, were violated by his arrest. Notice also, one of the things that happened in this, they voted to close the public comment period, and then they let someone else speak, and they let him speak because they were speaking favorably about the select board. And that didn't go well when eventually that was played to a federal court judge. So I guess I would say, and I understand the gentleman's concern about people saying libelous and slanderous things to you. Really, if you have a set of public comment meeting rules that limit those comments to 2 or 3 minutes, you're probably going to have to suffer through those kind of things. You can tell them to stop repetitive speech, but some of his speech may have been repetitive, but probably not enough to warrant cutting him off.
So could you do something creative maybe by somehow continuing the meeting for another time and have the public body leave at that point so that he would be still continuing his speech, but people wouldn't?
Yeah, I don't think that's going to work.
I'm just wondering, because we haven't stopped the speech, but we've actually continued
Yes,
the meeting.
well, yes, you have stopped the speech, because obviously you created a forum, and there's a whole analysis that would go into, you created a public forum, the forum is the public comment period and public body, and all of a sudden now you're taking the public forum and you're removing it. So I think there would be a problem in denying the right to speak to that particular person, because you didn't want to hear that person's speech. You didn't have a legitimate time, place, and manner reason to stop him from speaking. You stopped him from speaking because you didn't want to hear what he had to say. And that's problematic under public meeting rule procedures under the First Amendment. Yes?
He appeared aware that he had a 5-minute limit, so if
Yes.
you let him rant for 5 minutes, then what's the recourse system?
Nothing. 5 minutes, he's done. You say, okay, if he goes over his 5 minutes, then you can arrest him. So what I would just refer to was there was a case that was, when you're dealing with difficult people, this is Bear versus Leach. This is actually a case in the United States District Court for the District of New Hampshire, where one of the things that take place was a public comment period. Now, one of the things you can do at public comment period is not necessarily a question and answer session. So if I come up in public comment period and the rules say public comment is for your public comment, but it's not for you to engage in a debate with the council or with the board. It's your opportunity to comment. If you have a question, we'll try to get you an answer, but we're not required to answer it. So this was a situation where I think it was there was a school board also in the Lakes region where they had a public comment period, and this guy came up and he spoke in public comment, and then he started engaging in questions. And the board said, look, sir, this is not a question and answer session. You have something to say to us what you want to say. Your time is up. When his time was up, he went back to the audience, but then he kept speaking. And he kept saying, wait a minute, why didn't you answer my question? And I want to be heard. And the chair said, look, sir, you've had your 5 minutes. Now you're interrupting someone else. Please be quiet. And he had to be admonished 3 times. And eventually, a police officer was standing nearby, and the chair said, look, we've told this gentleman he's had his chance to speak. He's now interrupting someone else. He's continuing to pose questions which we're not required to answer. And eventually, he said to the officer, why don't you just arrest me? And the officer said, okay. And he arrested him. And under that circumstance, his behavior went so far, it was disturbing the peace and impeding the business of government. And when someone who is using free speech to do that, they could be arrested and removed. The same thing happened in the State versus Dominic case, a famous case in New Hampshire. It was a select board of 3, and there was one new selectman, which, look, I've seen it happen many times. The new select board member or council member, they're a lone wolf. They think they know better than anyone else, and they're going to reform town in one fell swoop because their thoughts and ideas are better than anyone else's. This person was a new member of the select board. The select board had rules of procedure, that each member would speak as they were recognized by the chair, and this one select board member was recognized. He was allowed to speak. But then he kept speaking when he was no longer had the floor. And he was told, look, don't interrupt. Someone else is speaking. Please be quiet. He kept interrupting. He interrupted again. And finally, the chair said, look, we have procedures here. When I recognize you, which I've done more than once, or I'm recognizing someone in the audience, please be quiet. Otherwise, you're impeding the business of government. Eventually, he kept speaking, and the chair of the select board had to have that selectman removed, and he was arrested. He then sued the town, saying his First Amendment rights were violated, and the Supreme Court said, no, you were impeding the business of government. You were misusing your free speech to impede the operation of government. So, yes, you can step in, but not in this situation with Jeffrey Clay. If he had just stuck to his 5 minutes and he just ranted about their inappropriate conduct as councilmen, in this case it was selectmen, you would have just had an earful, but then you'd be done with it. Unfortunately, what ended up happening is they had to, and this is the one thing towns don't want to pay, you have to pay the attorney's fees for the ACLU to the tune of about $50,000, which is a lot of money you got to spend to defend a situation where you can cut it off if you have effective public meeting rules. Time, place, and manner. 3 minutes, no repetitive speech, try to keep it to the items on the agenda, but people are going to rant, and you're going to have to expect that to occur. Yes?
Can you give an example of when you said regulate only time, place, and manner? Can you give an example of how you could regulate manner legally?
Manner?
Yes. Is it respectful manner, or are you talking about
No,
procedural manner?
it really isn't respectful manner. So time, place, and manner in that particular instance, you cannot use speech. Manner really goes to repetitive speech. So you could outlaw repetitive speech. You could outlaw fighting words. It'd be very hard to outlaw just obscene words in and of themselves. So generally, under the First Amendment, there are certain forms of speech that are not protected. So the classic rubric is you can't, and this was from the World War II case, you can't print in a newspaper the sailing time of troop ships that are sailing from America to Europe, because that would alert the Germans they could torpedo the troop ships. You can't, fighting words are not protected speech. You can't yell fire in a crowded theater. That's not protected speech. If it falls into one of those obscene speech is not protected speech, but the reality is, as long as it has some, it has to appeal to the prurient interest and has no socially redeeming value. So what it used to be is the porn stars would be reading Shakespeare plays while they were carrying on in their various activities in the porn industry, and that was seen to have some redeeming social value. So it's very difficult to regulate obscene speech. But fighting words, yes. If the speaker comes up from the podium and is saying, okay, Mr. Chair, let's take it outside and we'll fight about this, that's not protected speech. But, you can't regulate speech by saying you can only use speech which is friendly, or you can't use libelous or defamatory words. And that's where Alton got in trouble. Their rules of procedure said defamatory or inflammatory words were not permitted, and that was not permissible. Yes?
So we wouldn't be able to shut somebody down for using, say, obscene language, but...
A few obscene words, no.
But would it be appropriate to just ask for their, to concur that it may be not appropriate to use obscene language?
Absolutely. As a chair, you could say, sir, I want to admonish you that we have many people who don't appreciate that kind of language. I don't appreciate it. Please keep your language such that you're not using obscene words. Admonishment makes sense, but telling the person you're done because you just used the word F-U-C-K, that's probably not the best way to proceed. So again, the best approach is limit it to 2 or 3 minutes, limit it to items on the agenda, have a safety valve so people can speak on non-items on the agenda under reasonable circumstances, and just let it fly. And that's probably the best way to achieve compliance with the First Amendment. So I have really already talked about public meeting minutes at some length, so I won't go over that again. I've already talked about roll call votes and manner of doing roll call votes. So I've really covered pretty much all the topics. So we've done the 2 hours. I'd be happy to answer any questions, any additional questions you might have. Yes?
Just out of curiosity, the FCC has a number of rules about obscene language going on the airways, and you're televising these on CCTV. Is that any kind of announcement?
No. Okay, so the FCC, we're talking about over-the-air broadcasting. Cable, if you've ever gotten HBO, cable is not regulated in terms of the FCC, in terms of obscenity. When we're talking about FCC regulation, that's over-the-air broadcasting. That's radio, and maybe George Carlin had the famous 7 dirty words. And so the FCC does have the authority to regulate that kind of content, but it has a particular meaning. I won't get into the First Amendment details, but it has to do with the fact that there are children that might be able to hear it, and there's kind of rules about that. But that's just because it's over-the-air broadcasting. Cable stuff that comes over your cable system, such as local cable access, that's regulated totally differently.
So if the town had a radio station and were broadcasting the town meeting over the radio station, that would be.
Well, then you might run it, if you'd have to be licensed by the FCC, and then you might have licensure limitations in terms of how you have to comply with the FCC rules. So you probably, when you have those kind of standards, you have to have a delay so that you can have a gag, you can bleep things out. The TV stations, radio stations all have that. But I don't think any town really wants to have a live radio broadcast. It's usually your PEG channel, your public education and government channel. That's what those things are called. The PEG channel, which are available to you through the franchise arrangement you have with Comcast, assuming Comcast is your cable user in your particular municipality. Yes?
I just have a question, but in general, when you're having a town meeting, a lot of times I've been at meetings where I'm sitting back here, and they're conducting a business, and we have people in the audience who are making loud statements and things like that. Can the chair remove that person, or can they limit the whatever they're saying? Because in many cases, you can't hear what's going on.
Right.
Because the person's being disrupted.
Well, let me give you a suggested strategy, which I had recommended to me by a moderator. One of the things that's true, and I've seen this, I used to conduct processes where I was trying to manage large public gatherings, and there's things you learn about how to manage large public gatherings, and people are being disrupted, either in the back of the room, as the case may be, and preventing the meeting from going forward. One very effective strategy is, if you have someone who's popping off in the back of the room, you say, we're going to take a break. And the chair marches to that person, preferably with the police officer by his side, and say, sir, this is not appropriate. Keep it up. You're going to have to take steps to have you removed. You want to speak and come up with public comment period. You're sitting in the audience, we expect you to be quiet. And you speak to them face to face. Because one of the things that person wants is an audience. So if you're up with the public, speaking to the person, that's exactly what they want. They can pop off, and they've got the whole audience. You've got them face to face, and you're admonishing them, stop this behavior, we may have to remove you. A lot of times it's a very effective way to stop that right in terms of how it's going on. The person will stop much more quickly rather than being admonished, because they feel like it's a teacher talking to them in a room full of students, and that's just the kind of audience they want. So I think that's one approach. But if someone continues to pop off like that, you can say, hey, you continue to interrupt the meeting, we're going to have you removed because you're disturbing the peace and you're disturbing the business of government getting the job done. So that's just one thing to consider, how to deal with that. Any other questions? Yes?
So when you're talking about time limits, you were saying also that some boards have different requirements. So a land use board, planning board, zoning board could put time limits on, typically, at least in our format, is, the presenter speaks.
Yes.
People get up and are for or against whatever.
Right.
You can put time limits on that?
I think it certainly makes sense. Here's my concern, because I've seen this. Applicant comes in with the engineer for this, you got the drain engineer, you got the wetland scientist, they've got a battery of people, and one after another, and pretty soon, the initial presentation has taken up 2 hours. And the abutters are sitting in the room, they're fuming. Like, when do we get a chance to speak? So I think it makes sense to, in those kind of circumstances, say, look, we're going to let you make a presentation, but, this is not an application by filibuster. We hear from you, and then we only reserve 5 minutes for the abutters. So a reasonable management of time to respect the interest of all parties certainly makes sense, so you don't have the applicant suck up all the time and everyone else has to wait till 1 o'clock in the morning.
But do you have to notify the applicant in the group that the limit's 4 minutes, and if you so desire, you'll
Whatever, yes, you can certainly do that. The chair could do that at the beginning of the meeting, is to announce, look, we have a contentious application. We have to give it a chance for the applicant to be heard. He's got a few representatives who are in his engineering, list of parties who want to, they're experts who want to present information, and you're going to manage that time in a way that respects their interests, but also the interests of the abutters and other interested parties, to use the time effectively. And you're going to have the attorney who's going to bitch, moan, and complain about, I've got all these people, they're costing me all this money, they all ought to be heard. But you as the chair also has a duty to help the abutters participate and not have an applicant by filibuster.
So my question is, do we have to treat in our rules, say we have a 4-minute limit that may be enforced?
Well, I think you could have a standard operating procedure that might be modified given the circumstances. Or you might say, we have a set procedure where the initial presentation by the applicant can take no more than 30 minutes. If you need more time, you got to let us know beforehand. And then, when you start that public hearing on the contentious application, you let the other one in the room, the applicant's going to have 30 minutes to make their initial presentation. We will try to give as much or similar time to those in opposition to make a similar presentation. So there's fairness communicated to the parties who are there, opposed and supporting, so they know they're all going to have a chance to be heard. So you could put that in your rules, or you may have to modify it given what you have in front of you. I mean, you may think there's going to be a contentious application, the room's going to be full, and it may turn out not. Or you may turn out to have a room full of people, and you might have to say, okay, we're at agenda item number 3. It's 8 o'clock. We've said we're going to start the hearing now. Let's get going. But we're going to have to manage our time a little bit differently because we have a full room. The other thing, which is always very good to have as a rule, and this is something our planning board did, and I think any board can do that, is say we will not take up a new item after 10:30, because. It could be you start that new item at 10:30 and it goes for 2 hours. You're 12:30 in the morning. And I've had hearings go to 1 o'clock in the morning, and I'm going to tell you, there's nothing worse than having a meeting at 1:30 in the morning, and it's Thursday, and I got to go back to work Friday morning. It's a killer.
You do notice that it's at the board's discretion.
But I think cutting things off and say, look, we're going to stop at 10:30, or we're not going to take up a new item after 10:30. So those are some of the things you can think about to help manage your time. Again, because you won't know what's going to happen until you show up, and all of a sudden the room is full. Okay, we're going to have to be careful with how we manage the time on this one.
It kind of gets, instead of public comment, like maybe that Alton board meeting is, where obviously it's clear they have 5 minutes. Because planning boards and zoning boards are getting presentations.
Right.
So how do you notify that that 5 minutes is up? I know it could have something.
You might just have to say the chair is going to have to keep track of that time, and that person the time is up.
Of course, to say that's the limit at our discretion.
Yes, I think you can do that as long as it's fair to all concerned. I think that's the key thing. But to the extent you're going to have presentations in terms of the format for presentations, whether it's a ZBA variance application or a subdivision site plan, you probably should have some standard format for how it's done in your rules. Applicant will, in a standard presentation, get 15 minutes extended at the will of the chair, as the case may be, and put that in your rules of procedure, and then modify them as necessary given the circumstances. I had another question. Yes?
A procedure question. If you have several issues in the evening, could you have a list for people wanting to speak, sign a list, saying, I want to speak on this issue with
yes.
other people? And then you take that and you say, okay, I go down there as a way of kind of
absolutely.
keeping things under control.
And the other thing you can do is you can say, I think I've been very effective. Let's say people are now coming to speak on the ZBA application, and it's been a presentation by the applicant, and the butters have spoken, and you see a long line of people who are standing. One of the chair could say, look, before I hear you all, which you have a right to be heard, can I just have a show of hands of those who support the application? And no hands go up, that's fine. And then I can see the hands of those who are opposed to the application. Okay, are those who are here, is there one of you who oppose it who you think would best express your points of view? Oh, okay, you come speak, all right? And then that person speak, and then the next person comes up and say, ma'am, that man, did you agree with what he had to say? Yes. Do you have anything to add or anything new in addition? No, I think he said it very well. Okay, so you support his point of view. Great, thank you. And you can do that with all the rest of the people so that, you are cycling through. You're not telling them they can't be heard. You can say, oh, if you want something new to add, but maybe that person has already covered the topics. Or the person comes up and says, well, there's something else I want to add. Great, let's hear your different point of view, even though you're also opposed. And that's the way you can manage getting through it all. Either have a large number of opponents or even supporters, as the case may be. Another strategy. Again, the one that I liked, at the legislature, they have these orange cards. You fill them out when you come in, and the orange card says, we're going to have a testimony in HB 26. And you can check support or opposed, and the card is put in. And you can also check, do you want to be heard? And your name is on the card. And a lot of people just check, I oppose, and they don't ask to be heard. But the chair will cycle through them. Oh, I've got 15 cards from these people they are supporting, and 15 cards from these people they are opposed, and I've got these people who want to be heard. And then that can go in the public record. So you've actually had a chance for them to be heard in writing, but you didn't have to have them present testimony. Another strategy to get through a long public hearing with a lot of people who want to speak.